Good afternoon, everyone. My name is Raheel and I look after the international trade content at LexisNexis. We today are kicking off the second part in our introductory series of webinars on trade remedies. So today we're specifically looking at subsidies and the countervailing measures to counter the effect of those subsidies. And I am joined by two panelists, Raheel Shahid and Dr Bregt Natens, and I'll quickly introduce them before we start getting into some of the questions that they will share their insights on some of the things that might be key considerations, and other than bringing then any of these applications in order to counter the effect of the subsidy, or perhaps it is that you're on the defending side. So first off, we've got Raheel Shahid. He joined the Trade Remedies Authority as a lawyer in 2001, just after they were established. And he specializes in anti-dumping, subsidy and safeguard measures, as well as a wider areas such as circumvention, bilateral safeguards and transnational subsidies. He is admitted as a solicitor of England and Wales, and he has over 6 years of post-qualification experience. Other than that, he has 10 years of experience working in government, and he has gained regional management experience in established legal teams across London. He was a family law specialist for His Majesty's Court and Tribunal Services Legal Operations, and he also acts in a judicial role in England and Wales, hearing civil and family law matters. Dr Bregt Natens, he is a counsel in the International Commercial and Trade Practice Group in the Brussels office of McKenzie, and he regularly advises on EU and international trade law regulations, specifically with a focus on trade remedies, customs rules, market access, and regulatory barriers. Bregt has significant experience representing clients in litigation before EU courts, and as well as at the World Trade Organization, as well as before EU and EU member state authorities in the context of trade remedies and customs matters. Bregt regularly teaches trade law, and his research has been published in leading journals. So Bregt, if I may, let's kick off with you. Getting down to the basics first, what is it? When does a subsidy exist?
Thanks, Raheel. I'm happy to be here for the second session, and that's immediately quite a complex question, and I think the three of us will try to make this as concrete as possible, but it is quite a technical area of law, so sorry if we don't always manage to break it down as much as we should. So, as you said, Raheel, the topic of the session is countervailing measures, and countervailing measures are measures to oppose, to counteract, countervail the effect of subsidies on that are subsidies given to exporters of a certain product. So concretely, if you manufacture a good in the UK and you're facing import competition from, let's say, China, you wonder whether the Chinese producers with whose imports you are competing are being subsidized, and whether there's something you can do about that by bringing an anti-subsidy complaint. And then, as we said, first question is, okay, what is a subsidy? And the concept of a subsidy consists of basically four elements. The first is there is a financial contribution. The second is that financial contribution has been provided by a government body. The third is through the financial contribution, the recipient is receiving a benefit. And the fourth is the three elements before, the scheme under which the financial contribution has been granted, conferring a benefit, is specific. We'll break down some of these elements throughout the session, so I'll maybe leave it here for now.
Thanks, Brett. It's important. Just breaking it down, keeping it simple is the key. And so we've got the four elements. Raheel, perhaps you can elaborate how the Trade Remedies Authority assess whether a measure involves a financial contribution by a government.
Absolutely, thank you. I mean, generally speaking, obviously subsidies are so wide-ranging, and so having that framework definitely helps in narrowing things down for us. A financial contribution, which is one element, and is, I'd say, first of all, very distinct to the second element of benefit being conferred. And so we need to look at financial contribution by itself. And this is where there has been a financial contribution. It's an exhaustive list and set out in legislation. This is the reason it's exhaustive is because there's not all things that can confer a benefit would necessarily be a subsidy. The biggest example being if the government wants to privatize a national organization, that might confer a benefit, but we wouldn't look at it in terms of the financial contribution according to the list that we have. Looking at the list, then what we're looking at are direct or potential transfers of funds or liabilities, revenue that's otherwise due, that's foregone undergone by the government or authority. A foreign authority may be providing goods or services other than general infrastructure, a foreign authority purchasing goods, or a foreign authority making payments to a funding mechanism, or entrusting a private body to do any of those things that I've just mentioned. So it's really that sort of category of contribution from the foreign authority, the government in question, potentially to this industry. I'll leave it there on the financial contribution point.
Thank you very much, Raheel. Bregt, getting on to the second element, how do the applicants, or the defendants for that matter, how do they demonstrate that there has been a financial contribution that's either conferred a benefit on the recipient or not?
So I think here it's important to keep in mind that if you are a company that is complaining about the subsidization of your foreign competitors, then everybody knows, the TRA especially, that you only have imperfect information. A lot of this information will not be available and should not be available to you for antitrust reasons. So you can only provide the information that you have. Now, on the benefit, I think that is a particularly tricky one from the perspective of a company that's complaining about the subsidization. But it really does depend on the type of financial contribution. So the way we usually approach this with clients is you try to first map all of the existing schemes, support schemes that you are aware of, and then you start breaking them down one by one, and you take, for each of them, you try to find out whether there's a financial contribution, and then the next step is, does it confer a benefit? So when the financial contribution is something along the lines of a grant or a tax cut, then you regularly find information about the conferral of a benefit in the annual reports of the companies that received the grant or the tax cut. So for instance, grants are very often reported somewhere in an annual report. Tax cuts you can often devise by looking at specific rules that are listed in the notes to the annual report saying we benefit from a tax cut on our enterprise income tax or something along those lines. So those are not too complex in the sense that you can find evidence for them, and you know that if one company benefits from this in an industry, then it's quite likely that somebody else will also benefit from it. So you can sort of make allegations based on contextualization. When you get to financial contributions that are basically the provision of goods or services under their market price or costs, it becomes much more difficult. A classic example here is cheap energy. In many industries, energy is a huge cost driver. If you produce this same product in a country where energy is super cheap, then that might constitute a subsidy. But it's very hard for you to find much concrete information on the benefit that your competitor has gotten from getting this cheap energy. So what you then try to do is you take, for instance, the cost of energy in that specific country, and you compare it to an international benchmark, and you say, look, it's much lower. That must be the benefit. So you need to widen your scope a little bit and go away from your competitor to more general market dynamics. And so it depends really from scheme to scheme and type of financial contribution to type of financial contribution, how you approach the benefit analysis. But contrary to the dumping case, for those attendees who also listened to our webinar on that one, what's really different with a subsidy case is that there's a lot of, let's say, investigative work that has to be done by the people who are helping you bring the complaint. Much more than in a dumping case where you as the company often have the keys in your hands to a lot of the information. But here it's really almost like a forensic research type thing. And of course, if you've done this a few times, you know where to look and you know what to look for. But it's every single time you need to build this sort of, as I said, mapping, this sort of universe of subsidies that are relevant to the case at hand.
Fantastic. Thank you, Bregt. Raheel, so in addition to requiring that the measure must be a financial contribution by a government which confers then a benefit, the measure must also be specific. So how does the TRA determine if the subsidy is specific enough?
Thank you. Yeah, so at this point, obviously, we've identified that we've got a financial contribution and the benefit's been conferred, so we know we've got a subsidy. Then we look at basically the specificity of this subsidy in its application. And contrary to the literal meaning of specificity, the specificity can be wide-ranging here. What we're actually thinking of is, in essence, the question is whether access to the subsidy is limited to a particular class of recipients, and that's the essence of specificity point. What we're looking at is whether it's limited in terms of access to certain enterprises or industries, whether it's contingent on export performance, whether it's contingent on use of domestic over imported goods, and whether it's limited to specific geographical regions. And the way we kind of look at this is, well, are there conditions that are put in place for how the subsidy is applied? That would say that, de facto, this subsidy would be specific to something. Beyond that, it could be that although the criteria are very neutral for how the subsidy is applied, through its application, it could be specific. It could be that it applies to sort of, if we talk about, for example, energy, as we were, it applies to all energy manufacturers, and then in application, it's only given to green energy producers, and that's a sort of a problem in terms of the overall subsidy application. That would make it specific, and that's where we would say that becomes a subsidy that we can do something about. So in essence, that's specificity.
Fantastic. Thank you very much, Raheel. Bregt, I've got a two-part question. So firstly, even if all of the elements are present and we know that the measure is a subsidy, the subsidy must still be countervailable. So the first part of it is, how do we determine if the subsidy is countervailable? And then the second part is, you earlier referred to anti-dumping investigations in the sessions we had on that. Should the subsidized product also be this like product that we spoke about when we had the session on anti-dumping?
Let's start with the first one, Ariane. So yes, indeed, just like in anti-dumping, you have sort of a scope of an investigation that covers the like product. Different authorities have different names for it, but let's keep it simple and say like product, which is basically competing goods. So the way we always approach this is you look at the universe of competing goods, and then you consider whether there's something that somehow needs to be carved out from it. But in general terms, it's competing goods that you make versus competing goods from your competitors that are established and produce outside of the UK or EU or whatever it is, wherever it is you want to consider bringing a complaint. And those are the flows of goods, the sales of goods that are the subject to the investigation and the basis on which the entire investigation is based. On the element of the subsidy, I guess one thing we sort of glossed over, but it might be interesting to know, is when we said it's a financial contribution by a government, that the notion of by a government is also quite broad. As Raheel said, it can also be where a private party is entrusted by a government. And those are things that are quite fact intensive, but there's quite a lot of case law, and this won't surprise anyone, as to how, for instance, the Chinese government affects the entire Chinese economy. And therefore, a lot of actors that may look like they are private in China are often deemed to be entrusted or vested with governmental authority. In other countries, that's a bit more difficult, and you really do need to build a solid argument about that. But the ultimate goal of the breadth of the provision is to ensure that all government actions can somehow be attributed to that government, even if it is through relatively complex or opaque systems. So that's I think a pretty important one. Basically, tying it all together, the concept of financial contribution is very broad. The concept of by a government links pretty much everything that's really done by a government. And in some heavily influenced economies, it goes even a bit further. The concept of benefit is where most subsidies or potential subsidies go to die, because that's where you really get to the nitty-gritty of, does this really distort the market compared to a free market? Is there really a benefit for the recipient? Because the fact that you're getting loans from a government-owned bank doesn't mean anything unless the terms you're getting are better than the terms you would be getting on the free market, right? So the benefit is really where many things fall down. And the specificity depends a bit on the authority, but generally is also not too complicated to show. So it's really, I would say, the fight is on benefit, and in more complex schemes, it is really on by a government sometimes as well. Those are, I would say, the two tricky or sticking points. Now, when is a subsidy countervailable? Well, it's countervailable when you have the 4 steps. It's a subsidy, it's specific, it confers a benefit, blah, 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 blah. And then it is granted to the production of the goods that are the like goods, the like products that are exported from the country you're looking at to your home market. Because if this subsidy isn't somehow affecting the production cost of the goods that are being sold on your home market, they're not countervailable. because then they don't really matter to you at all. Now, you can stretch this quite broadly. If your competitor gets R&D subsidies, that might not directly affect the cost of production of a specific good, but it ultimately will if you take a more holistic perspective, which is what most authorities do. So you can go upstream, you can go downstream, I guess would be a bit rare, but it's quite unlikely. And you can even go sideways and think about cross-subsidization. But the most logical flow is the production of the product itself or its inputs. Those would be subsidies granted to the product that can then be countervailed at the border. Because the ultimate goal is to level the playing field between you producing in the UK and the imports that are competing with your products that are benefiting from subsidies in whatever other country.
Thank you very much for that, Bregt. Sticking with you for the moment, you mentioned earlier about when you're thinking of bringing this case, it's a little bit different than what you would do in an anti-dumping investigation, because they're the company wanting to, or at least the domestic industry wanting to bring that particular application. They would have most of the information in hand. But it's a bit more of an investigation / forensic investigation. I think that's the term that you used when you want to bring a application for countervailing measures. Typically, what kind of information would applicants use as evidence of subsidization?
So what you often see is that companies have a relatively good view as to what their competitors are getting. These things filter through left and right, but there's usually no consolidated body of evidence or something along those lines. It would be great if somebody had that, but I've never seen it. So what usually happens is you take your experience from previous cases, previous jurisdictions, and you sort of apply the same logic by basically sort of, again, mapping the existing subsidy schemes. You look at past practice, you do a bit of desktop research, and then you sit together with the people at the company who will have the best visibility on this. Typically, it's the salespeople who will have a decent view on this, and you try to sort of see whether this makes sense, whether there's something else they can think of, whether there might be something that they've heard of that's not there, or whether there's something on the list where they know, no, that is not relevant to our industry. So you narrow it down a bit like that, and then you do a deep dive into each of these schemes, looking for any evidence that's out there. And as I said, because you're not supposed to have everything, it means that whatever evidence you can find is sufficient. You just need to make a credible case to Raheel and his team that there is such a scheme, that the scheme exists, and that it's possible that your competitors have benefited from it. Once you've convinced the TRA of that, the TRA will open a case and send out a questionnaire, and then your competitors can say, we indeed benefited from this one, but we don't use that one. But that is really not the level of information you're supposed to or expected to provide at the initial phase. So the initial phase is really about the schemes that are out there and that in the industry you're talking about would make sense. And the evidence you find is anything you can find: a press release, an alert somewhere, an article in a journal, the annual reports that I mentioned before. All of these things are fair game, but it means that it's a pretty intensive and laborious process, and subsidy cases often have hundreds of annexes because they are trying to build this record that there is a good likely chance that A, the scheme exists, and B, the scheme has been used by your competitors. So it is it's for the lawyers, it's quite a substantial amount of work to pull all of this together.
And luckily still, Bregt, thank you very much for that. But luckily still, it's just you have to prove it on the face of it when you actually submit the application. It's not that it's definitive proof at that stage. There's luckily the investigative process that follows, and I'm sure we're going to speak about that in a moment. Raheel, now once we've gone through and we've proven that all four of the elements of the subsidy is there and subsidization therefore exists, is it then immediately possible for the Trade Remedies Authority to impose these countervailing measures to counter the effect of the subsidy?
Well, we're not quite yet. Obviously, subsidization is one element of what we're looking at. What we're addressing here are countervailable measures and countervailable subsidies, and what we're looking at is whether these subsidies are actually having adverse effects. As we've sort of discussed earlier, in the context of countervailing measures, we're looking at injury to the market, to the industry from these countervailable subsidies. So we need to sort of address that injury. We've talked about it in the previous webinar on dumping, but it's the same kind of elements. We're looking at the domestic industry, whether they've been injured by these subsidised goods being imported. And beyond that, we also need to, as Brett was saying, tie the subsidy to the products. If we think about the context of subsidies can be huge and wide-ranging, and it might not necessarily apply to certain goods. Factories produce all kinds of goods. If we're looking at a specific kind of good, it could be that the subsidy applies somewhat to them and also to other goods, and we need to then look at apportioning the subsidy to those specific goods in question. And then we also need to kind of go beyond that and look at apportionment, as Brett said, to the raw materials that might go into the production of those goods, and or
not so sure if it's just on my side, but I think Raheel is frozen. Maybe we'll wait until he's back. Bregt, if I may continue and maybe ask you a follow-up question on what Raheel was speaking about. And that is really, how does the industry demonstrate that subsidization actually causes an adverse effect and injury? Bregt, I think you're on mute.
Of course I am. This is really where the company's data comes back into play. So the injury determination is basically where the company shows that it has suffered economic harm. Welcome back, Raheel. Suffered economic harm from these the competition from these imports, and there's a relatively long list of indicators of this economic harm that the TRA and other authorities will look at. But if we're being really honest, the key ones are: how is your market share evolving? Has your market share gone down? And how is the market share of the imported goods that we're talking about evolving? Has that gone up? If the answer to those two questions is yes, that's already a pretty good indicator that you're not in a great place. And the second really important one is, what about your profitability? And is your profitability also going down together with your market share? Then there's an issue. There's a likely issue. Now, this is corroborated by a whole bunch of other indicators, as I said, looking at sales prices, sales volumes, cost of production, investments, return on investments, all these things. But it often ultimately boils down to market share and profitability, because these are drivers of the injury analysis. What happens is, or what often happens is, that companies will think about these types of procedures only when they've already felt the impact. And typically it starts with the sales guys who say, we're no longer able to make the sales at the same prices as we were before, or we're losing sales because we're not able to match prices of competitors, or we can only keep the sales by going so low in terms of prices that the business is angry because we're no longer getting to the right levels of profitability. So that's really like the canary in the coal mine is the sales teams having issues with their continued sales. It sometimes takes a while to let them flow through to the P&L, because it tends to be one market, and it might not be so pronounced at once. But so that's where it often starts, is with those specific metrics. Now, to then make the injury analysis strong and solid, you do really need to work with typically the controlling team in pulling together all these numbers. And that's often not so easy, because coming back to the like product again, we need the data for the like product only, and that might not be how a company reports. And so there's a lot of cutting and slicing necessary if there's no overlap between a reporting channel or a reporting line in terms of accounting and the like product. So that can be really a complexity there that requires quite a lot of man hours from the controlling teams. But at an initial stage, to consider whether it's worth bringing a case like this, if you know, again, your profits are going down, your market share is going down, and the market share of your competitors is going up, then that is I think a very good rule of thumb to say that you're suffering injury. What we should also say is, I was saying that sometimes it takes a bit of time to filter through. There's also this thing called threat of injury. which is basically for a situation where you can show that you're going to be injured, but it's not materialized just yet. But as you can imagine, this can only be done if you have credible evidence that the threat is imminent and that it's really coming, because otherwise it would be too easy to get protection on that basis. So you can do this in a situation where you're ahead of the curve and you've already prepared everything, but you're not yet feeling the full impact or the full brunt of the competition of imports in your P&L, but where you can show that there will be a flood of imports coming. A typical example is if you're producing in the UK and there's an anti-dumping or an anti-subsidy case in the EU and in the US, and you know those markets are going to be closed off from imports from, let's say, Korea, then you know that a lot of these imports are going to come into the UK because they need to be routed somewhere. So then you know that there's a big volume of imports coming to the UK, and if that comes at a time where you're already vulnerable, then that's credible threat of injury. So those, I think, are the two main scenarios. Either you're already feeling it, or you know that it's coming, and you don't want to wait, because, and we'll get to that, it takes a bit of time before you get these countervailing measures in place.
Fantastic, thanks, Bregt. If anyone listening wants to see what those measures are doing, you can, tag onto the many trackers that we have tracking these trade remedies, so you can see exactly in which jurisdictions we've got the potential of other anti-dumping duties or countervailing measures being imposed, and then there's a possible, as Bregt has mentioned, likely effect of those imports being rerouted into the UK. Raheel, as an industry, how does one go about applying to get protection from subsidised products?
Thank you, and apologies. I hope people heard me beforehand, and thanks for covering.
I think you definitely got the brunt of what you wanted to say, and luckily Bregt was there to fill in some of the details. Thanks a lot.
Brilliant, thank you. In terms of industry applications, then, what we're looking at here is certain requirements. I think, as we mentioned earlier, when we're thinking about how we could bring the case, it's similar to those elements. Really, what we're starting with is whether what the technical characteristics and current tariff classifications of the goods are. So we want to look at exactly what we're talking about here. What are the products? What do we need to do with them? We need to identify the exporting country or territory where these exports are coming from, the ones that you may be worried that exports from certain areas are causing the injury. We want to then look at the UK imports, the volume of imports from UK importers. We also need to then go on and consider the UK producers, the overall domestic industry, and we want to break that down by volume and value of production of goods in the UK. This is what's going to support looking at those elements in terms of injury, as Brett mentioned. And to go beyond that, then we want to look at the support or opposition by the rest of the UK producers in the market, before we look at then the exporter side of things and see, what's actually coming in from there. As you also mentioned, Raheel, we're looking at this on the face of it, so evidence doesn't necessarily need to be full and complete at this stage. It's more a case of, this is the indication that's how coming through, and this is where we see our injury coming from, and so we can then take steps from there. We do need some evidence of that injury, evidence of sort of effects of what's happening to prices to the domestic UK producers, if it's the UK, and trying to tie those subsidies again to that injury somehow. The goods that are coming in, making sure that they are potentially like goods similar to what's being produced by the exporters, and just showing that in the application form. As we've talked about already, there's quite a lot. It's a very complicated area here with subsidies, and when we're addressing what's been said, we then go on to look at this in the wider context. We look at sort of economic interest for the UK and see whether it's going to have an impact on them. We also look at public interest from the Secretary of State. Will then consider how any measures might be affected by the public interest. So there's a lot to it in essence, and it's just helpful if applicants, when they're coming in, to kind of address everything they can in that initial stage.
Thanks, Raheel. And then it's a follow-up question really on what you just mentioned. And it's two things. So if applicants are wanting to bring this, I mean, are they able to, approach the Trade Remedies Authority before they actually submit the application? And then the second part of that question is, I assume that there's some other, online form that the TRA has developed over the years that needs to be completed. So, this is something that people can go download and see. These are the kind of elements that you need to be addressing in order to bring it.
Absolutely. So just in terms of the program, the TRA, the Trade Remedies Authority, and maybe other authorities around the world also have similar mechanisms in place. But the TRA has what's called a pre-applications office, where discussions might be had to see that, what sort of information do I need to bring for my case? I'm a bit worried, and those conversations can be had before any applications are made. It's a sort of it's shut away from the investigative sort of process, and so those conversations can be quite frank and open. Once that kind of information has been gathered, then it will come to the stage to go through the process. And when we're looking at this, what we're kind of saying is, well, you've got your application, we need specific data and information. That's where questionnaires might be issued. These questionnaires can be looked at in advance. I mean, they are pretty much sort of accounting type questionnaires asking for facts and figures. And that's the kind of information we're really going to need to compare to the exporters as well, and depending on how the investigation proceeds.
Excellent. Thank you very much, Raheel. And then once the industry has decided that they're going to pull the trigger and they've now applied and submitted the application form, how long is it before they can expect to have the countervailing measures imposed?
WTO timescales apply, and within 12 months for final measures. Though preliminary measures may be imposed before then if it's a preliminary affirmative determination is made. But generally speaking, we aim to have that completed within that time frame.
It's quite a bit of time. Bregt, what are those various steps that the TRA needs to take within the investigation?
I think, and this is true generally around the world, is these are complex investigations. They take time. 12 months is indeed we would be happy if 12 months would be indeed the case overall everywhere, but it's quite regular that 12 months becomes 15 or even 18. So I think in fairness, what you should count as a potential complainant is, it takes 6 months to get your ducks in a row and have the application ready to file and sort of pre-approved by the pre-application office. That's not because it will take your advisors 6 months, but that's because from experience, we know that the controlling team is typically very busy and they need to do a lot of work on this. So that tends to be one of the drags. So if it really needs to be urgent, that's where some of the time can be nibbled off. And then it takes, I would say, I would be cautious and say 18 months until you get to a final conclusion. So that's a process of about 2 years. And that's a very, very long time if you're in a situation where you see imports coming in. And that's why it's so important that you don't wait until you're underwater, because then it might just be too late. But that you take steps, urgent steps relatively early on to consider whether this is a type of thing you need to be considering to apply for. You do get, as Raheel said, provisional duties, which already provide some relief, typically somewhere around 8 months into the investigation. But again, depending on the complexity, that can also be maybe 12 months into the investigation. So it's cautious to take 1.5 to 2 years before you're going to get protection from the moment you decide to move full steam ahead. Again, that is a long time, and so one of the things that we know authorities are sensitive to is if you're really in a bind, that you do whatever you can to expedite this, because things may change drastically over a period of 2 years, and your competitors will also have time to stockpile. So that's also something to consider and to take preventive action against. So the rules are quite, I would say, sophisticated in the sense that all these things can be dealt with, but they require good planning and good thinking through before you do this to make sure that you actually get something at the end of the road.
Fantastic. Thank you very much, Bregt. Raheel, so once the investigation has been concluded and there's agreement that subsidization exists, adverse effects and injury is there, we need to impose these duties in order to counter the effect of the subsidy. How long are these countervailing measures in place for?
Generally speaking, we apply measures for the time that the injury being caused needs to be counteracted for. So we look at the injury, put a measure in place. Generally, in the UK, we have legislation here that sets out that will be for 5 years, unless a period is sufficient to counteract the injury caused by the subsidised imports of the goods. 5 years is a sort of deadline, as it were, for the first stage of this. Beyond that, then there can be sort of reviews to see whether those measures need to remain in place to counteract that injury. But the first point of call is the 5 years, unless lesser period is sufficient to counteract any injury that's coming in.
And then also renewable every 5 years on the review?
Absolutely, yeah. So at the 5-year stage or pre-5-year stage, it'll be assessed. There'll be perhaps if there needs to be further measures put in place, then it can be reassessed, reviewed at that stage to see whether those measures should continue. Sometimes known as sunset reviews or expiry reviews, where again, not necessarily the whole process, but a process of investigation will occur where these measures are identified and looked at in the context of the sort of current climate and the measures having been in place for 5 years, the impact of what that has had on industry.
Thank you very much, Raheel. And Bregt, how did the authorities determine what the appropriate level of protection should be?
I think before going there, Ariane, it's a good question. Just one more note here. So the process is, we've basically said, not that straightforward, and it takes a long time. But why then do we see so many cases? Well, that's because what Raheel just said. In the EU, at least on average, so in the EU, we've been imposing duties since somewhere in the 50s. And so we have a nice sample size. And on average, duties remain in place for 12 years. So that's basically 2 full cycles. So one first cycle and then like a review in another 5 years and then a bit extra, but 12 years. So if you go through the hassle of this procedure and you have a solid case and you're indeed facing this competition from imports, then the upside is that you get protection for a very long period of time. And that protection, and that's then the question you just asked me, tends to be of the level that it really allows you to go back to the profitable levels that you were at before this whole injury started. So it can really make a huge difference to a company. And you see this also when you look at import statistics, because the volumes that are subject to these duties tend to drop quite drastically. And that, of course, also has an impact on price. So in many cases, the result of these investigations is that it becomes commercially pretty uninteresting to still sell to the UK or whatever other protected market there is, except for some specific niche circumstances or in case that there's a real need to continue buying. But otherwise, you see the import volumes just drop quite drastically for a very long period of time. And the burden to get the duties extended in what Raheel just called sunset review or expiry review is significantly lower than the burden in getting them in place, which is why you tend to have these 12 years of protection. So it is a long-term game, and it's not an easy one. But if you succeed, it's really a strong instrument, as it was always intended to be, because this has been part of the international trade rules since before any of the 3 panelists were born. Going to the protection level, so this is a really tricky thing with countervailing duties, and Raheel already alluded to it. The basic thing is the authorities will calculate a subsidy rate, and the subsidy rate will be basically the amount of subsidies allocated to the exports at issue, and that amount of subsidies will be converted into a percentage based on the value of these goods. So assume you get an allocation, and we won't go into allocation keys because that brings us too far, but let's say you have 100 million euros or pounds worth of subsidies, then that 100 million gets allocated to the trade volume. Let's say it's a billion, and then you would have a subsidy rate of 10%. And the 10% would be the basic anti-subsidy rate. There's other ways other things that come into this calculation, but this is like the basic calculation. What we often see, and this is something where the TRA will still have to expand on its practice and show us how it wants to do things. But at least in the EU, the subsidy rate typically comes on top of the dumping rate. And so if you bring parallel cases, you get higher protection. And subsidy cases tend to result, but it depends really, tend to result in somewhat lower protection levels than dumping cases. So in many cases, companies bring together dumping and subsidy cases to have a combined duty rate that suffices to restore the level playing field. And in the UK, it's a bit different because the rules are not particularly straightforward, and we don't have much practice from the TRA yet to know precisely how this goes. But so far, we're seeing that companies are also considering bringing both subsidy and dumping cases just to make sure that they get the level of protection that is really necessary and that offsets all the trade distortive behavior of their competitors in foreign jurisdictions.
Just to add to that, Brett, in terms of the UK and the approach, generally speaking, it's a case of the two elements that come into play here: lesser duty rule in making sure that any measures that are put in place for dumping or for subsidies don't go beyond the injury level that's been caused. And then after that, there's also an element of considering double counting, where we are looking at dumping. We don't necessarily want to penalise twice for any subsidies that might be in place, and that's easier said than done when you consider that subsidies sort of can impact more than just a product in many ways. As I said earlier, it can sort of flesh out, if you have a subsidy on energy, for example, how do you attribute that potentially to one product? And so it's quite a complicated consideration that needs to take place.
Yeah, and much appreciated. That is the current situation at the TRA. I think from the perspective of the applicant, because we don't know whether you're going to back out any subsidies from the dumping calculations, the sort of conservative approach is to just bring both, because then you're sure that whatever the behavior is, it will be counteracted, whether it's in the dumping side or on the subsidy side. In the EU, it's a bit different these days because we have a different set of rules on the application of the lesser duty rule. So there you see much more subsidy cases these days because there's a real benefit to bringing them on day one. In the UK, I think it's currently, at least until your practice is established, it's I would say prudent to bring both.
Bregt, looking at the EU, can you give us one of your typical stats? What's the typical rates that you would get in the EU over the 60 odd years that they've been doing it?
So sorry, go ahead.
No. Just what's the level pegged at?
So subsidies are particularly tricky. So in general, if the country is not China, then the duty levels tend to be relatively low. I would say low double digits is a relatively high subsidy for non-China. There are exceptions when there are huge raw material distortions. If your competitor is getting the key input for cheap, because of an export restriction in the country where they produce or something like that, then it can be very different. But in a normal set of circumstances, the duty levels in those countries tend to be quite low. In China, it really, really depends, and it's impossible to say. It can go from 3 to 70%, depending on the specific industry. I think the key ones that we always see yielding large amounts of subsidy percentages are input distortions. So getting cheap access to a key raw material is an absolute key subsidy, because it can affect 50, 60, 70% of your production costs. And so that really is a subsidy that tends to inflate the subsidy margins a lot. And then the other thing that, at least in China, yields high percentages is preferential financing, so cheap money basically, where at least many authorities have found so far that access to money in China is particularly easy compared to other places. The typical example is that in China, there are a lot of companies with a AAA credit rating. In the rest of the world, there are 2 One of them is Johnson & Johnson. I think the other one is Microsoft, but in China you have hundreds. And that's sort of a boutade to say it's a bit easier to get money there. So that tends to be a big one too. And you also see that state-owned companies tend to end up with higher subsidy rates than non-state-owned companies. So those are some rules of thumb. I think an interesting one is the EV case that is currently ongoing on battery electric vehicles. It's been on the Financial Times front pages quite a few times. But so there you see that the difference in duty levels between the companies that are exporting from China is very big. I don't recall the precise numbers because they've changed 4 times in the past couple of months, but I think Tesla is currently at something like 8%, whereas SAIC, one of the big state-owned companies, is at almost 40%. And that's the same subsidy schemes, the same products, just different amount of money being granted to the state-owned company than to a US-owned company. So with dumping, hard to predict. With subsidies, impossible to predict. That's my experience.
Hopefully, it's not the only takeaway for the day. Bregt, tell me, is there another way to obtain protection other than applying for countervailing measures? At someone like the Trade Remedies Authority.
So, as a company, I would say the answer is basically no, and your best shot is to do a dumping and/or subsidy case in the country where you're producing. This happens every day. It's what Raheel and I do constantly. It's ordinary course of business. There's a case initiated somewhere in the world every day, I always say. So this is the way to go. But there are exceptions, and in some situations, you might want to consider the WTO as an avenue to challenge these types of subsidies. The problem with the WTO is this is a government-to-government situation, so you need to have the ear of the government. And the remedies are much less appealing. So practically speaking, I would, in most situations, recommend an anti-subsidy case before the TRA or the equivalent somewhere else, except for the super high-profile things like the Airbus-Boeing saga, which has been litigated at the WTO for over 20 years and ultimately resulted in some form of resolution. But that was a very special case, I think. And there are a few other examples where the WTO turned out to be the right forum. So it's possible, but typically it would be a company would be well advised to consider doing it before the TRA.
Sorry, just going to say, as a lawyer, I think, the Airbus case is brilliant to look at if you're interested in subsidies, generally speaking, at the WTO level. When we are talking about subsidies, there's much more to it than this specific small area of countervailable duties that we've talked about. It's worth understanding what type of subsidy there is in play here. And usually it's more than just one, and that's why, as Brett said, that it can be so varied. You may be looking at many subsidies applying, and not just one in the case of a specific product or good. And just to add, there are certain things such as prohibited subsidies on where subsidies are contingent on exports and things like that can have a factor, and it just goes to show how sort of political subsidies can be, and it's worth understanding the wider narrative of what's happening in the industry when you're making those applications.
Thanks, Raheel. I see we don't have any questions posed yet by any of the participants or attendees. I don't know if someone still wants to pose a question. Perhaps we can rely on our panelists for their expert view on those. But if not, then the only thing is to remind everybody that we have our third webinar. It's scheduled for the 20th of November. That will be dealing with safeguards. So if you've got a sudden increase in imports coming into your market, so it's not the two nasty ones we speak about, international price discrimination, i.e. dumping, or then subsidization by a government or governmental entity or private body that's been given the authority to do so. These are simply because you've taken on some other commitment and people see there's a benefit to exporting to your market, start exporting to your market. So we'll be covering that and what the basics and the key concepts and considerations might be for companies either then seeking protection or perhaps needing to be involved in these kind of investigations. So that's scheduled for the 20th of November. It's again over the lunchtime, so hopefully we will have a lot of attendees who are able to attend. And I'll also be joined again by these two great panelists. to share their thoughts on that. And then that only leaves me to thank you both for the insights that you've shared with us, the time that you've given for us. We really appreciate it, and I hope the attendees benefited greatly from your level of expertise and experience that you've gained over the years. Thank you very much.
Thank you so much for having us.
Thank you for having us.
All the best. Bye-bye.